All right, so this is going to be the Plan F topic analysis for Jan-Feb. Resolve plea bargaining ought to be abolished in the United States criminal justice system. So I'm just sort of going to be walking through the how you should approach AFFS in terms of how to approach answering neg strategies, as well as deciding in what direction we should develop new specific parametricized AFFS. Rafi, I believe, is going to handle all sort of the util neg stuff, so this is more of the util AFF stuff. So first, I think that the most useful way for constructing AFFS to ensure that sort of maximize the strategic value of them is to start from the definitions of, or the relevant T definitions in the res, and then sort of work out what AFF is most topical that gets us the most amount of strategic advantage. So first is plea bargaining. So the definition that I found at the Legal Information Institute, which appears to be sort of the definition I think most academics and people who write about this are sort of working off of, which is plea bargains are agreements between defendants and prosecutors in which defendants agree to plead guilty to some or all of the charges against them in exchange for concessions from the prosecutors. So it appears then that plea bargaining has a very, very specific definition in the legal literature, which means that we probably couldn't write an AFF that was topical, and that could be one that was topical by say writing an AFF that was about something else like deferred prosecution agreements, which if you run into those while doing research, from my understanding, things like deferred prosecution agreements or delayed prosecution agreements are not the same thing as plea bargaining and are two very distinct terms in the legal literature. So just bear that in mind. If you see a term in an article that looks like it could be plea bargaining, do make sure to look it up before you pursue it any further, because there is a strong chance it will not be what you think it's talking about. The next, I think, relevant term is abolish, which means to put an end to something, such as an organization, rule, or custom. So it seems then that in order for an AFF to be topical, it needs to just completely get rid of all plea bargaining. Whether or not you can specify a subset to abolish is, I think, a different question. But it does appear that it is insufficient for the AFF to say that we are going to significantly reform or change plea bargaining. It has to be a total abolishment of it. Now, it could be interesting because it does potentially open the gates for an AFF that doesn't necessarily legally outright ban plea bargaining, but changes the criminal justice system in such a way that would induce the total abandonment of plea bargaining. That kind of AFF is very likely to be extra topical, or at the very least affects topical, but it is just an interesting concept to think about. So U.S. criminal justice system is the set of agencies and processes established by governments to control crime and impose penalties on those who violate laws. That's sort of the most generic definition I could find. And it is worth noting that the criminal justice system is splintered into different state and federal systems depending on sort of the nature of the crime and whether or not it crosses state borders, or if it involves federal property. But that is an important thing for considering the question of solvency on a lot of AFFs, whether or not, and I sort of haven't given this a ton of thought yet, but it does seem to me a relevant distinction as to whether or not the states or the federal government or acting jointly do the AFF. Okay, so here are sort of my first 2 cents on this topic when considering AFFs. So I think the first one is that we need to make sure to construct an AFF that avoids core neg disads, and this is just sort of a truism on all topics. The clog disad especially seems to be shaping up as the most prevalent disad on this topic, mostly just because it seems that a lot of people talk about plea bargaining as a sort of way to expedite a lot of criminal trials, which makes it easier for like the glut of cases to be pushed through the courts. Now, the fact that it's happening to the criminal justice system has interesting implications for the sort of how the DISAD will be shaped, and that should definitely sort of form a large part of our AF block to this DISAD. Since a lot of the impacts I can see in court clock DISADs usually have to do with civil courts and things like IP suits, which are not something that happen in criminal justice courts. The next big thing, and I think this is especially important, especially if we want to have like a high success rate on the AF, is to be able to answer generic advantage counterplans, which necessitates that we find abolished key arguments. Like, we have to find advantages that say that are only solved through an abolishment of plea bargaining. Because otherwise it then becomes just way too easy for the neg to sort of counterplan out with any of the advantage counterplans that I've listed here, like legalizing drugs or repealing war on drug laws, increasing prosecutorial discretion of crimes, changing policing policies, or increasing funding for things like public defenders. Those are just sort of the ones I thought of off the top of my head for as potential neg strats that the AF will have to beat. That is by no means comprehensive. But that should sort of give you the idea of what kind of counterplans the negs are going to be very predisposed to read, and that we have to make sure that our AFs are tailored to have solvency deficits against those counterplans. Otherwise, I think we are guaranteed just a set number of losses every tournament, and that's not the sort of strategic position that we want to be putting ourselves into. Likewise, we need to make sure that these AFs are also equipped to handle generic picks, where people are probably going to pick out of like certain crimes or populations that should not be given or that should be given plea bargaining. I can't think of any like prominent examples off the top of my head right now, mostly because those would all sort of make good AFs. But we need to be able to prepare for someone who's going to pick out of like a specific crime that should have plea bargaining in it, that has like some sort of internal net benefit. Especially since I feel like the theory arguments on picks bad are going to be weaker on this topic than they normally are, just because it also seems like a very core part of the neg of sort of topic literature is pointing out like instances in which like plea bargaining is probably good and that like a total abolishment is probably bad, which probably means that the neg should have access to some pick ground. But that's of course a separate theory issue. But those are sort of those three things are the sort of things you should keep in mind when you're trying to figure out what AF to write. This is why, in particular, I think whole res AFs are very unstrategic on this topic. That sort of just read like a generic structural violence advantage, because those AFs are very easily solved by like any advantage counterplan that does structural changes to the criminal justice system. And like it seems like, and from my cursory research, it appears that like the vast majority of authors write about those types of approaches, which means that the counterplan, I think in those cases, too easily solves the AF, and then it becomes just a question of winning a net benefit. But those are just my 2 cents on the topic. Obviously, it will be shaped by sort of how the topic literature ends up developing and how people sort of approach negating and affirming this topic. So I think one thing I want to talk about before we get into any type of specific AF is the question of federal versus the states. So most crimes and trials happen at the state level. You only are ever prosecuted in a federal court if you violate a federal statute or the nature of your crime ends up crossing state borders, or it involves federal property in some way. Which means that by and large, most of these trials end up happening at state courts. So it then brings up a relevant question of who should be doing the plan. The resolution is incredibly ambiguous about who is doing the plan. It doesn't say who is abolishing plea bargaining, and that sort of gets into like which actor is the most relevant. Like, should the federal government pass a new law saying that plea bargaining is no longer allowed? Should the 50 individual state governments all do that as well? Does the Supreme Court rule that plea bargaining is unconstitutional? That is all a question that is left ambiguous by the resolution, and there are, depending on which one ends up being the right one, there will then just be a built-in solvency deficit to the ones that aren't that actor. So if it ends up being, like, so for example, if it ends up being the case that it turns out that it probably should be the federal government that passes new legislation that says that plea bargaining should not be allowed, it seems that then any act that defends the 50 states has an implicit solvency deficit to it, and vice versa. And this is honestly more of a neg thing, but I just wanted to throw this out there. But depending on the nature of the AFF, we should also definitely have a viable states counterplan and politics dissad strategy, or a USFG counterplan plus a state politics dissad ready to go on the neg in our pocket. That just gives us a really good generic neg strat to read against an AFF, whether or not they defend the states or the federal government. Okay, so in terms of the specific types of AFFs, we're going to start with the courts AFFs. So I personally think that this is the most strategic on this topic because a courts AFF will get you mechanism advantages that can't be solved by most generic neg advantage counterplans. So how a courts AFF would look is generally means that a judicial body, most likely the Supreme Court, will issue a ruling that says that plea bargaining is unconstitutional and should not be practiced under any circumstances. And then that ends up setting the legal precedent and ensures that plea bargaining doesn't happen anymore in the United States. What I mean by mechanism advantages is that there are oftentimes certain like legal doctrines that are caught up in different court cases, and those can end up being like really good advantages that are unique to courts AFFs and are not solved by a advantage counterplan that says like legalize drugs. So I think the ideal structure then for a courts AFF should be like one topical advantage that's like sort of based in the topic literature about like, you know, why plea bargaining is problematic, why it does like terrible things, and then one mechanism-based advantage. A mechanism-based advantage, if you like need an example of it, I am currently looking for one on this topic, but in past topics in both policy and LD, mechanism advantages on courts AFFs have involved various legal doctrines. For example, last year I think Georgetown had an AFF where we read an advantage based on the Chevron doctrine, which is this sort of constitutional doctrine that was established by the Supreme Court that was about how federal agencies interpret congressional statutes and whether or not the agency or Congress should be given leeway on how to interpret a particular law and the text of that law. And we had an advantage based off of that. That was a distinct impact then from the normal global warming impact we were reading about. If you have questions about like more in-depth questions about what this will look like, I highly recommend you Slack me, and I can sort of talk you through it and send you sort of any relevant examples as necessary. I've dug up a couple court cases on sort of what are the relevant court cases to sort of look into regarding plea bargaining. I am definitely sure that this is not a comprehensive list because there's been a ton of court cases that have ruled on like what plea bargaining practices are acceptable or not. These are just the ones I found early on / that I think are particularly important. So the two that are 2012, Lafler v. Cooper and Missouri v. Fry, these were both court cases regarding the constitutionality of certain procedures within plea bargaining that have sort of shaped the uniqueness on court-based AFFs since 2012 based on most of the articles I've seen. So those are ones definitely worth reading about. I believe they have something to do with concerning the right to a lawyer or to public counsel and how that is affected by plea bargains. The third relevant court case is Brady v. U.S., which happened in 1970, and it was sort of the main court case that initially established that plea bargaining was a constitutional practice when that was first becoming an issue. If this is not in the PowerPoint, but I believe that there is a court case coming up called Lee v. United States, and so if we are concerned about test case theory, we can sort of throw that into the plain text, and as sort of like that will be the test case that the AF uses in order to rule in case that is a concern. Okay, so the next set of AFs that is worth talking about are subset AFs. I think that this is questionably topical since abolish could imply that all forms of plea bargaining have to be removed from the criminal justice system, or even the term in means that it has to be in the entire U.S. criminal justice system. However, that being said, they are incredibly strategic since they sort of skirt the core topic just as like the court clause just said, which should also sort of be how we frame our negative T arguments. But I think sort of the way that we can go in this direction is that we can either abolish plea bargaining for specific populations or for different types of crimes or specific types of plea bargaining. So I think the first two are sort of the same. I know it's been discussed on the Slack already about abolishing plea bargaining for people who have committed who are accused of like things like intimate partner violence. So that does sound like a good AF. Whether or not that's topical remains to be seen, but that's sort of an example of how that AF could work. And it skirts things like the court clause just said, because obviously, or like just abolishing plea bargaining for one specific crime is probably not going to collapse the entire U.S. judiciary system. So that's out there. I think the third type of specification, i.e., banning specific types of plea bargaining, it would make for interesting AFs. Once again, there's a core issue of topicality, but the idea behind this AF is that there are specific practices that happen within plea bargaining that a lot of people take objection to. For example, there are objections to using the death penalty as a way of coercing plea bargaining. What that means is that, for example, a prosecutor will walk in, will like tell a defendant, we are going to pursue the death penalty if this case goes to court, you should take the plea. And because people don't want to die, they take the plea. But that can be seen as coercive and sort of as a denial of proper due process, which could sort of be the basis for why plea bargaining should be banned underneath the court's AF. And this ends up being strategic because it sort of gets us out of having to defend the abolishment of plea bargaining writ large. Is still questionably topical, or at least could be one that it's topical, and sort of is designed to like beat core neg strategies in that it doesn't completely gut a huge part of the U.S. criminal justice system, but rather makes a sort of more incremental reform to it that is likely more feasible and has actually good authors backing it up in the core topic literature. In case y'all haven't noticed, it appears that the last time anyone took the idea of getting rid of plea bargaining writ large was in the 70s when this was first an issue before the Supreme Court. So it seems like we could also make this an AFT argument where we just point out that there is no author who takes seriously the idea anymore that all of plea bargaining should be abolished in the United States. Okay, so the last thing I want to sort of talk about is in terms of util apps, is sort of the advantages we're going to explore. This is just the cursory list I thought up of while sort of looking at the articles I was reading, / what is generally the usual arguments that are made when these sort of topics present themselves. So splitting it up into structural violence versus big stick impacts. Under structural violence first, I think the first one I thought up of was the disparate impacts that result from the war on drugs. So there is a wealth of literature that talks about how much drug criminalization laws have had disparate impacts, and that it ends up being minorities who are incarcerated at far higher rates than whites due to both discrimination that is baked into the law as well as discriminatory policing practices. And because of the nature of plea bargaining, this means that they often end up going to prison for sentences that they did not commit, they end up going to prison for crimes they did not commit, or for crimes that probably should be legal, etc. And sort of it can be thought of as the AF is at least a way to alleviate the discrimination that is exerted through these policies. The second one, domestic violence / IPV stuff, sort of talked about that earlier when I was talking about the subset AF, so that could also work as an advantage under a whole res AF. So it seems like there are articles that talk about how there should not be plea bargaining for people who are being prosecuted for sexual assault crimes, because that sort of denies justice to the survivor, and so that lends itself easily to a structural violence advantage, about how that can sort of give catharsis or justice to a survivor who would otherwise be denied those things under a plea bargaining system. The third one, which I actually think makes for a really interesting advantage, is torture. So plea bargainings can be sort of seen as sort of, especially given how prosecutions often exaggerate their charges in order to get better pleas. So that could be construed as a form of, like, especially if the defendant doesn't know sort of the resources that are available to them or how the trial will play out, they are sort of left in the dark and just have a prosecutor bearing down on them with a 40-year prison sentence. They're obviously going to take that. And that could be construed as a form of torture or unjustified exaggerated punishment. And there is authors who write about plea bargaining in that light, about how it ends up being coercive and not really a cooperative form of criminal justice. So that is another argument that seems to present itself easily. In terms of big stick impacts, sort of an extension of the war on drug stuff, there is a possible cartels impact, since cartel violence is intimately tied with how U.S. drug criminalization laws work. The exact internal link chain would be is right now is a little foggy to me, but I think there's a very conceivable scenario where plea bargaining or like the abolishment of plea bargaining makes enforcement of drug laws harder, which sort of cuts into works its way to cut into cartels' profits, and that is necessary to prevent escalating cartel violence. If you have questions about what that scenario could look like, you can just Slack me. The second one I thought up of, which would be a really interesting advantage, is sort of a legal modeling argument. So it seems that a lot of countries have modeled their plea bargaining systems after the U.S., both either independently or as a direct result of U.S. Legal development of other countries. So it seems that if the U.S. were to reform its plea bargaining system, other countries could model what the U.S. does and sort of form their criminal justice system after the U.S. So if there is a unique problem with the criminal justice system that stems in another country, but that happens to model the U.S., it would seem then that we could have a modeling advantage in which that country is able to fix its problems if it models its criminal justice system after the U.S. and how it abolished its plea bargaining. So that's sort of the util apps topic analysis for JanTab. This was by no means comprehensive, and most of it was just sort of how I thought about the state of the topic literature or what I saw in the couple articles that I've read. But I think the biggest things that you want to take away from this are the stuff I said at the beginning regarding app strategy. Even if none of the specific apps that I talked about just now ever end up panning out, these are sort of the principles that you should keep in mind, because they will sort of building a strategic app from the ground up has to go jump through these hoops in order to have an app that is viable and that will stand up to most next strategies in most rounds. Okay, so that's it. If you have any questions about any of this, feel free to Slack me.